Good afternoon. I call this meeting of the General Laws, Housing and Consumer Protection Subcommittee meeting to order. Members will indicate their presence on the electronic voting board. A quorum, the clerk will close the roll. A quorum is present. All right. First up on the agenda is Delegate Leftwich here. Delegate Leftwich, did you want to come say a few words before I just go ahead. Tell us what we're going to do to your bill.
Yes, thank you.
Tell us about your bill. That's it.
Chair Simon. So this is House Bill 2570, and I've talked to various members of the committee. Do not think this bill will pass in its current form. So my request is going to be that it be struck and give me some time in the off season to try to come up with a different version.
All right. Thank you, Delegate Leftwich, for your economy with the committee's time and your willingness to take this step. So with that, is there a motion to strike House Bill?
Second.
2570. It's been moved and properly seconded. The clerk will open the roll. Members will cast their votes. The clerk will close the roll. Bill is stricken from the docket by a vote of 8-0. Thank you, Delegate Leftwich.
Thank you for letting me take care of this quickly.
Delegate Carr, you have a witness who's got a time constraint and needs to get going. So that's for House Bill 2149.
2151.
Oh, I got it back. I had a 50-50 chance, and I was wrong. House Bill 2151. Go ahead. Why don't you present?
Thank you very much. Thank you for your consideration. Mr. Chair, HB 2151 is a technical cleanup bill that amends the code to reflect how community land trusts are actually operating. Requiring corporate membership is defined by any adult resident in a geographical area creates practical and financial burdens for the CLTs. Some CLTs cover a large geography. For example, Maggie Walker CLT operates in the city of Richmond and the counties of Chesterfield and Henrico. It would be practically impossible to communicate what our work is about to all residents and to allow all residents to be members of the CLT and have the ability to elect the board of directors. It's unclear how such a vote would even be structured. CLTs take very seriously their commitment to community input. Richmond ensures that the community they serve has input to elect CLT homeowners to the board of directors, as well as individuals who are representative of the communities they work in and serve. The goal is to have 1/3 of the board consisting of homeowners, 1/3 consisting of people who have lived experience in the communities we work in and or lived experience with affordable housing challenges, and then 1/3 of the directors from the broader community. And Mr. Chairman, I have here a witness who's very involved in the Community Land Trust, Laura Lafayette, and I'd love for her to testify on this.
All right. So normally we would have questions from the subcommittee members. We're going to let Ms. Lafayette go and give her presentation first. I would note from Ms. Lafayette's information, I have heard from no one who's opposed to this bill. So just for what it's worth.
I'll be very brief. It's always good when practice aligns with the law of the Commonwealth, and if we make these changes, the practical ways we are operating will now align with the laws of the Commonwealth. Thank you.
All right. Does anybody have any questions for, go ahead and, if you wouldn't mind staying at the podium.
Sure.
If anybody has any questions for the patron or for the witness? All right. Seeing no questions, is there anyone else in the audience wishing to speak in favor of the bill? Anyone wishing to speak in opposition? All right. Committee operates by motion.
Second.
It's been moved and seconded that the bill report. The clerk will open the roll. Members will cast their votes.
I reckon I can second on Bill, can I?
The clerk will close the roll. The bill reports 7-1. Thank you, Delegate Carr.
Thank you, Mr. Chairman.
All right, for all of you all witnesses following along at home, that is perfect testimony. That's like the model you should all aspire to. All right, Delegate Krizak.
Good afternoon, Mr. Chair, members of the subcommittee. House Bill 2134 before you is a bill that comes from the Commission on Updating Virginia Law to reflect federal recognition of Virginia tribes, on which I serve as the chair, and Mr. Chair, you are a member of it. We met 3 times during the off-season, and I want to thank my fellow commission members for all their work, including the representatives from each of our 7 federally recognized tribes, and our legislative members, and Senator McDougal, who's carrying the companion bill in the Senate. What this legislation does is it creates a new code section titled State and Tribal Relations and further establishes consistent definitions for American Indian, federally recognized tribe, and Virginia recognized tribe within the Virginia Code. This change would bring long-needed consistency and clarity to the state code, acknowledging tribal sovereignty and aligning more closely with current federal definitions. House Bill 2134 affirms our ongoing commitment to the tribes and provides a much-needed reform to our current code. And I would like to invite Mary Guardino from the UVA Law Clinic, which has been providing us significant pro bono work and research over the past 6 months for our commission in drafting this legislation, to walk us through this technical changes in the bill. Thank you, Mr. Chairman.
Thank you. Again, welcome. It's good to see you again.
Thank you.
And I know this is a fairly meaty bill for folks, but I do want to sort of put a finer point on what Delegate Krizak said. This is not just a one-off. This isn't the first time this has been vetted. There's a commission that we created by statute last year. That commission met pursuant to its statutory charge, and this has been through a great deal of vetting and almost like a mini code commission type of process, but within just these sections of the code. And so a ton of details probably not necessary, but if you want to kind of run through the major changes for the committee's benefit, that would be great.
Thank you, Mr. Chairman. Good afternoon, Mr. Chairman and members of the committee. My name is Mary Gardino. I'm a student at the State and Local Government Policy Clinic at UVA Law. The opinions I express today are my own and not that of the university or the law school. As Delegate Krizak and Mr. Chairman mentioned, my clinic partner, Thomas Ross, and I have had the honor of doing research to support the work of the commission. I'm here today to ask you to support HB 2134, which is the commission's recommendation and a necessary step to update Virginia law to reflect the federal recognition of 7 Virginia-based tribes. As Delegate Krizak explained the background in the bill at the commission, I will provide a brief overview of 4 primary components of the bill. First, it creates a new section in the code for state-tribal relations. Second, to create consistency and with considerable input from Virginia's tribal leaders, the bill creates 3 new terms and accompanying definitions: federally recognized tribes, Virginia recognized tribes, and American Indians. The first term, federally recognized tribes, refers only to those Virginia tribes with federal recognition. It's important to specifically refer to those tribes that have federal recognition, as it's a formal status that comes with eligibility for certain federal benefits, enables coverage by federal statutes, and recognizes the sovereignty inherent to tribal nations. In addition, the term Virginia recognized tribes is a more inclusive term that will now cover both federally recognized tribes and state recognized tribes that have yet to receive federal recognition. The term American Indian was a unanimous preference of the commission and refers to duly enrolled members or citizens of a federally recognized tribe or Virginia recognized tribe. For the third component of the bill, using these new terms, HB 2134 cleans up 39 inconsistent definitions in the code. Once again, these terms are restricted to those tribes geographically located in the Commonwealth, and the bill updates the code with these new terms only in places where doing so would not create any policy changes. Finally, this bill includes a statement affirming tribal sovereignty. Tribal sovereignty is the status of self-governance, which is similar, though not identical to, that enjoyed by the states. It's worth pointing out, this statement does nothing to actually change the legal authority that federally recognized tribes already possess, but it does take the important step of formally acknowledging the government-to-government relationship between the federally recognized tribes and the Commonwealth of Virginia. When questions arise, both tribes and relevant state and local actors can look to the code for a clear expression of the inherent sovereignty of federally recognized tribes within the Commonwealth. HB 2134 is an important step in the Commission's mandate to reflect federal recognition in the Virginia Code. For this reason, and the reasons you'll hear from other speakers today, I ask you to support this bill.
Thank you.
Thank you.
All right. Any questions from any members of the subcommittee for Delegate Krizak or his initial witness from the UVA Law Clinic? All right. Seeing none, is there anyone in the audience wishing to speak in favor of the bill? All right. Come forward. Line up. Again, this bill, I think, has a high likelihood of success unless we hear something that causes our ears to perk up. So for whatever that's worth.
All right. Wingapo, Netetaweens Rebecca Hill, Pamunkey near Ninawa. Hello, my name is Rebecca Hill. I am a Pamunkey tribal citizen and a council person. I'm here today to ask for your support of HB 2134, a bill to update the Virginia Code to reflect the presence and inherent sovereignty of federally recognized tribes headquartered in the Commonwealth. The Pamunkey people have been present on this land, which is now the Commonwealth of Virginia, for thousands of years. And the Pamunkey Indian tribe was recognized by the federal government in 2016. Federal recognition has enabled our tribe to exert our inherent sovereignty to protect and benefit our people and land. Sovereignty creates sort of an equality between the federally recognized tribes and the state. As a sovereign nation, our tribe now has access to federal funds supporting housing, health services, and education initiatives for our citizens. Additionally, government-to-government consultation rights provide us with avenues to ensure the adequate protection of our historic and cultural sites, safeguard that our tribal natural resources are factored into federal decisions, and allow us to reunite with our ancestors. This bill will establish consistent terminology and clarity and clarify the relationship between tribal nations and the Commonwealth. Thank you for your consideration on this issue, and we ask for your support. Ina.
Thank you. Next.
Good afternoon. I'm Lou Ratchford, the Assistant Chief of the Upper Mattaponi Tribe in King William, and I appreciate the privilege of asking for your support of House Bill 2134, which will update the Virginia Code to reflect the presence and inherent sovereignty of federally recognized tribes in the Commonwealth. Your passage of this bill will result in greater clarity and consistency in the law, by removing outdated and inconsistent terminology that does not fully reflect the unique status we hold. Since achieving federal recognition in 2008, the Upper Mattaponi Tribe has leveraged their status to open the Ailet Wellness Clinic, which serves all of King William, not just our tribal citizens. We've established a food bank and also a tribal community garden to promote the good health of our community. We've also been hard at work restoring land and streams in the area and are looking into adding indigenous species to the Mattaponi River watershed. We are proud of our long history in Virginia and in the many ways in which our tribe has contributed to our state. As written, however, the Virginia Code doesn't fully recognize the existence of federally recognized tribes. And this bill will provide greater consistency and clarity regarding the government-to-government relationship between the Commonwealth and federally recognized tribes in Virginia. We thank you for your consideration of this important issue and respectfully ask for your support. Thank you.
Thank you.
Mr. Chair, members of the subcommittee, Zach Lemaster with Gentry Lock Consulting here on behalf of Preservation Virginia, statewide nonprofit focused on preserving Virginia's historic places and communities, and we support the bill.
Thank you. Excellent testimony.
Mr. Chairman, members of the subcommittee, Trip Pollard, Southern Environmental Law Center, we support the bill. Thank you.
Thank you. All right, and we've got some folks online, and so we'll move to the online queue. We've got Thomas Badamo. Mr. Badamo? If I'm saying that wrong, please correct me.
Yeah, no, you're saying it correctly. Badamo is correct, and I thank you for this time. I am a tribal council member for the Nansemond Indian Nation, and I request your support for House Bill 2134, which we know is to update the Virginia Code to reflect the presence of federally recognized tribes within the Commonwealth and their inherent sovereignty. I've been
Mr.
a member
Badamo,
of the commission.
Mr. Badamo, I'm sorry. If you're looking at notes, they might be covering up your camera. So every time now and then you turn the page and you turn white, just to be aware. Your screen turns white.
Yeah. So, I've been a member of the commission and we've thoughtfully reviewed the code and find quite a few inconsistencies. And I think that updating the code will foster a better understanding and a real government-to-government relationship between the federally recognized tribes and the government of the Commonwealth. We're doing things within our community like starting businesses, like Fishing Point Healthcare, which is serving members of the community as well as members of the tribe. We've started an initiative to return oysters to our local waterways. But outdated and inconsistent terminology within the code is posing obstacles to some of these efforts. So what I will leave you with is a prayer that I hope we can all relate to, that may the Creator grant us the strength to bring about positive change, the serenity to accept what we cannot change, and the wisdom to know the difference. And I believe that through this bill, we'll all get a little closer to that. And I thank you for your time.
All right, thank you. Next up is Michael Tuponce? Help me. Tuppence. I just read it like it sounded. Mr. Tuppence, go ahead.
I'm the chair of the Legislative Council of the Chickahominy Indian Tribe Eastern Division. Everything I want to say basically has already been said by the other members, so I just want to say that we support the bill.
Thank you, and that's also a great example for those of you that are in the room. No need to repeat votes. They go before you. I usually give that admonition, but thank you for handling that for me. And then next up is Ann Richardson. Is Ms. Richardson online? All right, not seeing her there. All right, is there anyone in the room wishing to speak in opposition to this bill? Seeing none, the bill is back before the committee.
Move to report. Second.
It's been moved and seconded that the bill report. The clerk will open the roll. Members will cast their votes. The clerk will close the roll. The bill reports unanimously. It'll be on the uncontested docket 8-0. Thank you, Delegate Kriesek, and thank you everyone who did come and testify. I know that you've all worked very hard on this. I didn't mean to cut anybody short. I do appreciate you all and the effort that went into this important bill. So thank you very much.
Thank you.
All right. Next up, let's see. We should probably take Delegate McClure. I think hers is hopefully easy. Well, I might have jinxed it.
Good afternoon, Mr. Chair, members of the subcommittee. I have an amendment in the nature of a substitute.
All right, is there a motion on the substitute?
So moved.
It's moved and seconded that the subcommittee adopt a substitute. As many as favor of that motion will say aye.
Aye.
All those opposed? All right, the substitute's before us.
All right,
Delegate McClure, do we have copies of it, or is it going to go up online in a second, or do you already give them permission to put it online? It's online. All right, it's available online. Go ahead, Delegate McClure, describe what your substitute does.
Yes, Mr. Chair, they're just amendments to clarify the bill's intent, so it just rephrases it so it's more clear. And then, if I may, Mr. Chair, I'll go ahead and continue to describe the bill.
Go ahead.
HB 1867 requires landlords who own or have at least 10% interest in more than 4 rental units to give a 60-day notification if they decide not to renew a tenant's lease. Virginia is currently experiencing a rental housing crisis due to high demand, increasing rent, and lack of affordable housing. It is extremely difficult to find rental housing, pack up belongings, and move to a new building. I know this from experience, and it's nearly impossible to do so on such a short notice. This bill allows renters to plan ahead and avoid unnecessary stress. So the 60-day notice for lease non-renewals is already required by Virginia Code for landlords who offer month-to-month leases and manufactured home leases. This bill simply brings notice requirements for landlords with more than 4 rental units into alignment with other landlords. So, Mr. Chair, I hope it is the will of the subcommittee to vote in favor of HB 1867.
All right, any questions from members of the subcommittee about this bill? All right, is there anyone in the audience opposed to this bill? All right, seeing no opposition, if you want to line up and tell us you support the bill or you want to raise your hands, I'll do it either way. Everybody who's here to speak in favor of this bill, please stand up. All right, there's a whole bunch of people standing up to support this bill, familiar faces to many of us. The bill's back to the committee. Delegate Price.
Yes, thank you, Mr. Chair. I'm sorry to slow this down. I remember that for some of the housing bills, we added in the exemption for those that own 1 to 4 for some of it. But for some things that we do, all of the landlords are included. And I also remember that when we do that exemption, it's something close to like 220,000 units of housing in Virginia that are not included when we do that exemption. And I do not want to do anything that would harm you. I just have to ask for those 220,000 people if there could be any consideration in removing that exemption for this one.
Mr. Chair, Delegate Price, I am open to a friendly amendment to the bill to reflect Delegate Price's comments.
Well, all right. Well, now we're going to have to hear from people. Okay. Before we adopt that amendment, let's go ahead. Does everybody here? Everybody understand what Delegate Price is trying to do? Okay. So come on up. Line up real quick. Well, I know you guys are going to support it. Let me ask this: if anybody from AOMA or VAMA or the Realtor Association have a problem with that? Come on up.
Good afternoon, Bisma Ahmed with the Apartment and Office Building Association. We support the bill as written. Do you mind clarifying what the change was, Delegate Price?
Let's hear from council that she understood the change. Did you understand? So, okay.
Mr. Chair, I was speaking in hypotheticals and quick, so let me go back and say, so there were some things that we have passed since, let's say, 2020 that have the exemption for smaller, own 1 to 4 units, right? But there are some other things that we have passed that were for all properties. And so I was checking the temperature, as it were, about for this particular one being for all of the residential rental property.
Yeah, as a general concept, we have no opposition with taking out any exemption.
So I think
doesn't affect us.
Yeah, just real quick, I think the folks that might have a problem with that, if anybody, would be the realtors, because they generally have the interest of the smaller landlords. Is there anybody here from the Realtor Association in the room at the moment? They're not here. Oh, here's Aaron.
They're figuring it out.
I think this is already in your standard form lease, and it is, pretty much the industry standard. But
Thank you, Mr. Chair, for putting me in a very difficult situation.
And we can have it go by temporarily if you want to, and we can come back to it.
Erin Corman with the Realtors. We were just informed about this and are not going to oppose the change.
Got it. Understood. All right.
Mr. Chair.
Delegate Price.
I would move the amendment as described by council. Or did she do it?
So is there language we need to strike out of the substitute that would achieve that? Delegate Coiner.
Thank you, Mr. Chairman. So what is the penalty for not providing the notice?
Mr. Chair, excuse me, was that directed at me?
Yep.
Oh, thank you, Mr. Chair. Mr. Chair, I would say to the delegate that Department of Housing and Community Development doesn't have any oversight or administrative obligations regarding the Residential Landlord and Tenant Act, but they do update this information and make sure that, this is law. And so in terms of the enforcement piece, we could do better on enforcement, but I have some attorneys here who can speak to that.
I guess, Mr. Chairman, my question is more if I'm a landlord that only owns one unit, right, and I don't know this law, and the tenant doesn't get notice, is there action to sue me? Am I getting sued? And for what? What is the remedy?
So I think, Chair, we'll let, I'm the chair. So I think the answer is that the notice is ineffective is what happens, right? So somebody says, hey, you got to get out at the end of the week, and you say, no, I don't. I have 60 days before I have to get out, and here's where the VRLTA supports my position that I actually can stay in the property until 60 days have elapsed. Would you agree with that?
Thank you, Mr. Chairman. Christy Mara with the Virginia Poverty Law Center. Yes, absolutely. And it would, to take it one step further, if that landlord, for whatever reason, went ahead and filed an eviction case against that person anyway. That case would probably be dismissed and they would have to refile. So it simply would, it wouldn't be any penalty. There wouldn't be any negative consequence other than to say, okay, you really do have to give them another 30 days or whatever the case may be.
Does that answer your question, Delegate?
Yes, Mr. Chairman, speaking to the bill.
All right. So here's the other thing, and I think this goes to this amendment in concept, right? So I'm looking at the bill, and the way to accomplish that means we have to look on lines 81 through 88 in section K, and that actually changes a little bit what your bill is trying to do. Your bill is trying to align the notice of rental increases with a notice of termination. If we take out the carve out for the notice of termination, we would also be taking out the carve out for the notice of rent increases. And that might be okay.
Mr. Chair.
But in other words, to keep them in alignment, we'd have to take out the carve out for both. And I just want to make sure all the stakeholders have a chance to absorb what we're doing, because we're working on the fly. That's all.
I move that the bill go by temporarily.
Okay? All right, we'll take this bill by temporarily. Delegate McClure, we can come back. Maybe you can huddle with some folks and see how this could work.
Thank you, Mr. Chair.
Okay? I did jinx it. I did jinx it. It's my fault for calling this one easy. I'll take a really easy one. Delegate Siebold. I've been waiting for a presentation with props for a while, so that's why I called on Delegate Siebold.
I wasn't ready. I'm ready now. Hello, Mr. Chair, members of the committee. There is a substitute.
All right. Is there a motion on the substitute?
So moved.
It's been moved and seconded that we adopt the committee substitute. As many as favor that motion will say aye. Those opposed? All right, the substitute is before us. Delegate Siebold, House Bill 2542.
Mr. Chair, if I can explain quickly the substitute.
Take your time.
Thank
We're
you.
working on something over there, so go ahead.
DLS informs us that what we had was a certain section was unconstitutional, so we amended that piece of it, and so all the contracts moving forward will, our bill can apply to the contracts moving forward starting July 1st, and perhaps council can explain that a little further if you have any questions.
Sorry, can you say that again? The part you said? So the substitute does what?
Okay, so the substitute essentially says that this bill will apply to contracts moving forward starting on July 1st. It will not apply to existing contracts
Gotcha.
already.
So this is prospective only as far as declarations, right? So the contract is sort of the declaration, which is the contract that helps form the association. And so any declaration that gets filed after July 1st of this year would be subject to the terms of this bill, but currently existing HOAs and condo associations would not be affected by whatever this bill does. Is that right? And that's the main thrust of what the substitute was about?
Mr. Chair, that's what I understand. Again, defer to the council if I've said anything incorrectly. This change was a result of a suggestion that DLS provided to us.
Gotcha. All right. Go ahead. You can tell us about the rest of what the bill does then.
Okay, great. All right. Mr. Chair, members of the committee, amateur radios, also known as ham radios, are essential parts of emergency infrastructure. The FEMA administrator described them as our last line of defense when everything else fails. In fact, many hams work with emergency management entities, including, but not limited to, FEMA, American Red Cross, the National Weather Service, Civil Air Patrol, Salvation Army, and many other organizations. Amateur radio volunteers have communicated critical information efficiently during emergencies, including the Boston Marathon bombing, New Mexico wildfires, and Hurricane Katrina recovery efforts. Moreover, amateur radios were classified as critical infrastructure during the COVID-19 lockdown in 2020. Yet many hams across our Commonwealth have to operate in secrecy, often having to hide their antennas in trees, banished by homeowners associations, brushed aside as just a mere hobby. Mr. Chair, if you don't mind, I have some visuals for you.
Sure.
Come on, guys. These are my interns, Mr. Chair. They're very excited to be here. We have in front of you.
Just for what it's worth, I love this because they wouldn't let me do this in the Senate, so I enjoy a good prop. I tried something like this last year, but go ahead.
In front of you, Mr. Chair.
You guys can hold those a little bit higher. For those of us in the back row. Thank you.
We have a wireless internet tower, which is permissible in an HOA. We have satellite televisions, which are antennas, which are permissible in an HOA. And we also have, yes, that is, a flagpole, which is permitted in your yard in an HOA. However, Mr. Chair, what is not allowed is a radio antenna for amateur radios. That's what we see right here. So, thank you, gentlemen. Appreciate your presentation.
Here for the interns.
Mr. Chair, our bill, HB 2542, just ensures that amateur radios are treated equally to other over-the-air reception devices, and ham operators are not discriminated against from placing their antennas on their own homes. Hams are heroes and should be treated as such, and I thank you very much, Mr. Chair.
All right, I thank you, Delegate Siebel. I will ask you, though, real quickly. So it's not that ham radios are never allowed in an HOA. It's just the HOA does have the option to prohibit them. Is that right?
Yes, Mr. Chair.
Okay, so they could be allowed if you could convince your HOA board of directors and your neighbors and so forth to allow them.
Mr. Chair, that's correct.
Okay. All right. Any other questions from members of the subcommittee? All right. Hearing none, is there anyone here wishing to speak in favor of the bill? Do we have anybody online wishing to speak in favor? Go ahead.
Mr. Chair, we should have someone online.
That is, sorry, thank you. Benjamin Hofstadter. Mr. Hofstadter. Is Mr. Hofstadter online? See?
Is that him?
No, that's Mr.
Maybe he's against.
He's against. Yep. So he's against. All right. All right. Is there anyone in the room wishing to speak in opposition to the bill? Please come forward.
Mr. Hofstadter.
Oh, wait, Mr. Hofstadter is on. Belay that for just a second.
Thank you, Mr. Chair.
We'll go in the right order. Mr. Hofstadter, if you could turn on your camera. I see you're getting tuned in, and go ahead and make your presentation. Thank you.
Yes. Can everyone hear me okay?
Yep.
Okay. Thank you so much for your time. Good afternoon, members. My name is Ben Hofstadter, and I'm one of Delegate Siebel's constituents. As well as a licensed amateur radio operator. I'd like to thank her for introducing this bill, a bill to provide relief to amateur radio operators who live in homeowners associations and condominiums. I also want to thank her dedicated staff who have worked very hard on this bill. I'd like to add some comments to reinforce what Delegate Siebold said. Thank you again for your time. Amateur radio, also known as ham radio, is one of several radio services sanctioned and administered by the Federal Communications Commission. Amateur radio is a fun hobby that offers opportunities to learn about science and technology, and amateur radio operators, also known as hams, can communicate with others around town, across the country, even across the world. They assist their communities in good times by assisting with public events and also provide life-saving emergency communications at no cost to taxpayers. Amateur radio can be a lifeline when the internet and cell phone services that we rely on so heavily stop working. Amateur radio stations are safe because by law, hams must be licensed to operate and they must comply with safety regulations and guidelines. Amateur operators must ensure that their equipment does not expose themselves or others to harmful radio frequency levels. When operating from a home, several types of antennas can be used, including simple wire antennas, vertical antennas, which basically resemble tall sticks, or directional antennas. Their size and visibility varies. These can be mounted on the ground, in trees, or the side or roof of a house. There are more than 750 50,000 amateur radio operators licensed in the United States by the FCC and about 21,000 licensed operators in Virginia. Interestingly, about 23% of Virginia's total population lives in a homeowners association, according to the American Radio Relay League. So although difficult to quantify, many amateur radio operators like myself face private land use restrictions, including HOA covenants and founding documents that inhibit or even prohibit their ability to operate radio equipment from their homes. For example, in my HOA, my covenants that were approved half a century ago only permit TV antennas and forbid homeowners from mounting any other type of antenna. Any attempt to amend these covenants requires 77, in my HOA, 75% of homeowners to vote in favor, and that's an extremely high bar and unrealistic. To advance the amateur radio hobby and public interest benefits that amateur radio brings to our communities, we need legislation that will allow ham radio operators to operate their equipment. I ask that you please consider supporting this bill that will help amateurs for the future, but if at all possible, please consider any changes that can take place to the bill that could help people such as myself with some retroactive action. And thank you so much.
You're very welcome. All right, we've got anybody in the room wishing to speak in opposition to the bill, please come forward. And again, I was trying not to have to put a timer on, so we'd like to keep these comments brief. We have a lot of bills to get through today. Go ahead.
Good afternoon, Mr. Chairman, and members of the committee. My name is Tiago Bezerra. I'm the chair of the Virginia Action Committee of the Community Associations Institute, and today we are speaking in opposition to the bill. In Virginia, there are 10,000 community associations and over 2 million residents residing in community associations. We have not had the opportunity to see the substitute, but understanding that the expectation is it's only supposed to apply to declarations moving forward and not to abrogate covenants, which is one of the biggest concerns that the LAC has. At the end of the day, when it comes to the FCC, when it comes to the ham radios, and there's no dispute that they serve a valid and important purpose to all residents of the Commonwealth. The FCC, which continues to license these operators, have never and continue to refuse to impact covenants or to hold them in the same esteem as some of the other over-the-air devices that the FCC has previously regulated and required associations to do. And then finally, the only comment I have to say is that this bill, there's other than Mr. Hofstadter's one statement here, this isn't a problem that is pervasive throughout the Commonwealth. Associations are private contract that all the homeowners agree to when they buy into associations, and that those contracts and the ability of the associations to adopt and enforce practical and rules that can be implemented are really important. For those reasons, we are in opposition to the bill.
Thank you. Anyone else want to speak? Pia, Ms. Trigiani, excuse me, come on forward. And again, if somebody said most of what you want to say before, there's no need to always repeat it. You can emphasize it, a few key points if you need to.
Thank you, Mr. Chairman. I'll be fast. Pia Trigiani, practicing lawyer representing common interest community associations, primarily in Northern Virginia, but all throughout Virginia. We're opposed to the bill. The bill, as the prior speaker mentioned, covenants and restrictions are something that are established by contract. They're contract law. They're recorded among the land records. When someone purchases in a community that has restrictive covenants, they expect those restrictive covenants to be enforced and complied with. By taking nicks at it periodically through changes in the law, it does not create certainty in contract, and it violates the Constitution of Virginia, which does not allow adopted legislation to modify existing contract. So for those reasons, we're opposed to the bill. There seems to be a continuing effort to, when one single individual feels disenfranchised by their covenants and restrictions, to seek legislative redress for it. Unfortunately, that's not the way to do it. It's to amend the covenants and restrictions. Because if I live next door and I don't want an antenna next to me, I should have the same authority and the same protections that I understood would be there when I purchased that home. So thank you very much. I have not looked at the substitute, so I can't speak to that either, but glad to look at it.
Thank you. All right. Anyone else in the audience wishing to speak in opposition? Seeing none, we have 2 folks online. We'll start with, sorry, I'm using your list. Mr. Elliott. Just one phone call. Mr. Gianni is here. So go ahead, Mr. Elliott.
Good afternoon. My name is Keith Elliott, and I am a association manager of HOA property in Ashburn, Virginia, 2,100 homes. And in conversation with the Covenants Committee and others within the HOA, and they opposed this bill. And I would echo the comments of Pia Trigiani. There's no way that I could speak as eloquently as she is, and I want an interest of your time. I would just yield my time to what Pia stated and what I relayed to you regarding the HOA that I manage, that we oppose that bill. Thank you.
Got it. All right. Back to the committee. Any questions for the bill's patron? All right. So before we do that, I know that the patron has worked very hard on this bill and has made a lot of effort to try and address particularly the legal restraint or considerations. I know the post facto changing of covenants by the legislature is something that's troublesome to a lot of folks. And so by having this only apply going forward, I think you address some of that. I do think that there's more to talk about as far as what the nature of the exemption would be going forward and whether this is the right approach to take and whether it needs any modification. I do think it's a idea that could benefit for some more work and some more study. And we talked about this at last week's meeting. But you know, there may be a motion to report. I haven't heard a second yet. I would be more inclined to vote for a motion should one be made to lay this bill gently on the table and refer it to the Housing Commission so we can go ahead and take a look at what sort of policies we want for radio antennas. And maybe there are other kinds of antennas and other things that would need to be included that could make this a more comprehensive bill. So that would be the motion that I'd be more inclined to support.
Mr. Chairman, I'll move that we lay this very gently on the table and I'll move forward with the letter.
All right. Is there a second?
Second.
All right. It's been moved and seconded that the bill be laid gently on the table. I know that I've talked to the Uber chairman about sending a letter having this referred to the Housing Commission. He seems inclined to do that. So with that, the clerk will open the roll. Clerk will close the roll. Bill reports is laid gently on the table by a vote of 5-2. Thank you very much.
Thank you very much, Mr. Chair, members of the
Thank
committee.
you for your hard work on this.
Thank you.
All right. Delegate McClure, are we ready? All right. Let's go back a step to House Bill 1867. And do we have peace in the valley?
We have peace in the valley, Mr. Chair. I'm happy to report. So if I could move forward with the substitute that you all moved and then the bill that I described.
Okay,
so the original.
So we're not going to do the amendment at this time?
Not the amendment this time.
All right. All right. So we have a bill, the substitute probably before us without amendments. Did we take testimony on this? Oh, we did. We saw the raise of the hands and we saw we did everybody in line. So with that, can I get a motion to report?
Mr. Chairman.
Delegate.
Just
Pointer.
for
Yep.
just for clarity,
Yep.
we're back to only the larger landlords. Is that
Right.
correct?
Yes, that's correct.
Move to report.
All right, it's moved and seconded. The bill report with substitute. Clerk will open the roll. The clerk will close the roll. The bill stays on the uncontested docket 8-0.
Thank you, Mr. Chair,
Delegate
members of the
McClure.
subcommittee.
All right. Joe, what do you have on the docket? Do you have something on the docket? All right, Delegate Kilgore, why don't you come on up? You have one easy one. Delegate Hernandez, yours is not easy. I'm sorry.
Hey, I've got hopefully a quick bill. It's House Bill 2203. Right now, DHCD is required to produce 25 annual and limited reports each year. This bill would allow them to produce a single consolidated report that includes all the statutorily required reports. Multiple due dates will be rolled into a single due date on October the 1st, providing for earlier reporting for those report than they normally are. So this would just be streamlining and promote government efficiency. That's all it does.
All right, any questions for the bill's patron from members of the subcommittee? Anyone here wishing to speak in favor of the bill? Anyone in opposition to the bill?
Mr. Chairman.
Mr. Chairman.
Thank you, Mr. Chairman. Delegate Kilgore, I guess I just wanted to make sure that none of the reports got dropped out in terms of the data being presented, that it's all intact, it's just all on the same date within a streamlined report.
All in the same book. It'd be a book.
Thank you, Mr. Chairman.
All right.
Second.
It's been moved and properly seconded that the bill report without a substitute, just as it was written. Clerk will open the roll. Clerk will close the roll. Bill reports 8-0. Thank you, Delegate Kilgore. All right, Delegate Tran. She pulled rank on you. She pulled away from behind you.
Mr. Chairman, members of the committee, thank you so much. I do have a line amendment.
All right, hold on. What bill are we on?
We are on 2218.
All right, House Bill 2218, and there's a line amendment. The clerk want to report the line amendment? Or do we want to adopt it?
Yes, Mr. Chairman, the line amendment is available online, and it is on line 84. After fees, insert comma, unless the landlord offers an alternative method of payment that does not include additional fees.
So unless the landlord offers an additional method of payment.
An alternative method of payment that does not include additional fees.
Second.
The amendment's been moved and properly seconded. As many as favor of that motion will say aye.
Aye.
Those opposed? All right, the amendment is properly before us, so we have the bill as amended.
Great.
Delegate
Thank you.
Tran.
Thank you. I really believe that nobody should be required to pay a fee in order to pay their rent. And this bill aims to alleviate the burden of rental payment fees. So we are asking that landlords accept payment in all lawful forms for rent and security deposits. So this includes a check, electronic funds transfer, debit or credit card, cash, and money order, and including at least one of those forms that does not require a fee, and that they provide a written receipt to tenants who pay their rent in the form of cash or money order.
Got it. All right, and we passed a bill very similar to this last year. Is that right, Delegate
We
Tran?
did, sir.
Okay.
It was a little bit expanded, so this is just narrow on this issue.
Okay. Any questions from members of the subcommittee for Delegate Tran? All right, seeing none, is there anybody in the audience wishing to speak in opposition to this bill? All right, anybody want to indicate their support? A lot of thumbs up out there. All right. And we have one person online who wishes to testify very quickly on this bill, which has already passed once, House Bill 2218. Ms. Williams. If you want to unmute.
I didn't sign up for this bill, but I support it. Thank you.
Thank you. Perfect. All right. Is there a motion? Oh, Dahlia Price.
Yep, no, that I was just going to move to report as amended.
All right. Is there a second?
Second.
All right. So before we vote on the motion, Delegate Coiner.
Sorry, Mr. Chairman, my lines were not popping up on the iPad. So a question in 80 through 81, the way I read it, the landlord would have to provide means to pay by all of those methods. Is that correct? Is that what we're intending to do?
Yeah, they must be willing to accept all those methods of payment.
And they can, and Doug, I think Delegate Tran will ask you a question, but they have to offer all those. They can charge for any of them as long as at least one method is free. So if they have an office where people can come pay cash, then they can charge for all the other things. So to the extent that there's a cost for offering some of these services, they can pass that cost along as long as not every method that you have to pay also incurs a cost.
Correct.
Got it.
Follow-up question, Mr.
Delegate
Chair.
Coiner.
I mean, are we confident that all landlords take credit cards? I mean, I thought part of the original purpose of this was that it was, for some, the only method they were taking and passing along fees associated with this. I'm just wondering if we have landlords that currently don't offer all of these and don't charge anything, but now we're asking them to add additional payment methods that they're not currently using. Or if that's the intent of the bill.
Mr. Chairman, I would respond by saying that is the intent of the bill, is that a tenant can pay by any lawful means their rent.
Right, so Delegate Tran, I guess to Delegate Corner's point, so I have a rental property, just one unit. I don't have a contract with Visa or MasterCard or anybody to accept credit card payments. Am I in violation of this portion of the code? I can't take a credit, I don't know how I would go about accepting a credit card payment directly to me. I've got Venmo, they could use their credit card to pay my Venmo, but I don't know if that would comply with this because I don't take credit cards.
Mr. Chairman, I would respond by saying that this bill would require you to offer that option for your one tenant. And if your tenant says, I don't want to pay by credit card and I can pay by these other means that you already accept, then that seems to be, you would meet the intent.
Mr. Chairman, if
All right, so I guess to the motion, still speaking of the motion?
Still speaking of the motion, right. Mr. Chairman.
Yep.
I guess what I understood before the changes and last year, because I think last year in concept, I was supportive of it in concept. I thought the intent was to stop landlords if they only gave you an option that required you to pay a fee with that option. We wanted to make sure they offered another option. What I think has happened in the work in this section is to say you have to accept any and all options, and at least one of them can't have a fee, which I'm not sure was the original intent. I see heads over here nodding. So I think the language doesn't match, at least when folks met with me about trying to get to a yes this year, was not, I'm just not sure all the words came together in the way I thought based on what stakeholders came and talked to me about they would. So I was trying to get to a yes. I'm not sure in its current form it met the intent of what I heard from people.
Mr. Chairman, last year's bill was in 2024, and this year's bill, our intent was to expand the options so that tenants can pay their rent by any lawful means and give them those options to be able to pay their rent. For some, paying by credit card is the best method for them, and for others, it's paying by cash or by money order or by check. We want to make sure we're providing that flexibility for tenants.
All right, so let me ask a follow-up question to my question here for a second, which I think is, so I'll take a check for free. I'll take Venmo for free. Mm-hmm. My tenant insists that the law gives them the right to pay by credit card. Then I can go and find out what it takes to sign up with Visa and pass that cost along to the tenant. If I do
That's
that, the
correct.
tenant's 99 out of 100 times, the tenant say, no, I'll just use your Venmo or I'll use one of these other methods. So it won't actually cost me anything to do that as long as I offer them one free method. I see folks
I believe so, yes.
All right, that addresses my concern. I don't know if it helps with Delegate Quinter's concern or not. So, all right, so we still have the motion seconded for the bill to report. Delegate Price.
Yes, thank you. I just wanted to speak to the motion.
All right, speaking to the motion.
So I've actually been hearing a different concern that this bill would address. When I went to meet with some older Virginians back in my area, that they were encountering housing that would only allow credit cards and also online payments. And so some of the older folks were finding, our more seasoned neighbors were finding it hard, and it was a fee. So I think in this bill, it addresses two issues. And so I think it's even more comprehensive in that nature, and would have them, I think there already was a motion. Yep. So just wanted to say thank you, because this addresses a concern that I had heard from Peninsula Agency on Aging.
All right, any further questions or discussion of the motion? If not, any substitute motions? All right, hearing none, the clerk will open the roll. The clerk will close the roll. Bill reports 4-3. Thank you, Delegate Tran.
Thank you so much.
Thank you for allowing me to think this through out loud while we did it there.
It's always good to think out loud, sir.
Mr. Chairman,
Delegate Carr.
does this also include like for business rentals?
Yeah, this is residential, not commercial rentals.
Okay, thanks.
All right. Delegate Hernandez.
I just got here, so it's.
Just got here, it's fine. Delegate Hernandez, which one do you want to start with?
Let's do 1872, Mr. Chair.
All right, House Bill 1872 from Delegate Hernandez. Are there any amendments or substitutes we need to deal with?
I do not believe so, Mr. Chair.
All right. House Bill 1872, go ahead. Present your
Great.
bill.
So this bill builds on wonderful legislation from last year from Delegate Hope. That was HB 73, that passed unanimously in both the House, Senate, was signed into law by the governor, that set up the automatic expungement process for eviction cases resulting in dismissal or that were voluntarily non-suited. That automatic process started as of July 1st, 2024. For cases before that, you still have to go through the petition process. This bill adds further protections to help effectuate the intent of that law. So under this legislation, it says you cannot deny housing, you cannot increase the rent or the security deposit, or have more restrictive lease terms because of a prior UD that resulted in dismissal or voluntarily that was non-suited or is otherwise eligible for expungement. I think this is particularly important because remember, under the automatic expungement law, there is a waiting period before that expungement kicks into place. So if a case is dismissed, you have to wait 30 days. If the case is non-suited, the expungement happens 6 months after. And during that window of time, we want to make sure that those tenants are not suffering financial discrimination just because the expungement has not already occurred. So it's like I said, it's a minor addition to help make sure we're protecting these tenants that are going to get their cases expunged anyway, and happy to answer any questions about the bill.
All right, are there any questions for the bill's patron, from members of the subcommittee? I understand what it does. All right, anyone here wishing to speak in favor of the bill? Oh, Delegate Price, do you have a question? No. Oh, sorry. All right, those folks wishing to speak in favor of the bill, please come forward. If you keep your comments brief, and then if your point has been made by a previous speaker, there's no harm or no shame in saying you just didn't get to line fast enough, and you can just say what they said. Go ahead.
Great. Thank you, Chairman and members of the committee. My name is Laura Dodds with Housing Opportunities Made Equal. We've been receiving quite a lot of complaints from folks who go to apply for an apartment, and one of the first questions on there is, have you ever had an eviction filed against you? And if you say yes, you get kicked out of the application, can't even submit the rental application. Even if your eviction case is getting expunged, there are over 500,000 previous dismissed and non-suited eviction cases just from 2019 to today, and all those people are getting denied housing because of eviction case that they won. I urge you to support the bill. Thank you.
Good afternoon, Mr. Chair, members of the committee. I'm Gustavo Espinosa with the Legal Aid Justice Center, and also on behalf of the Allies for Housing Action, we strongly support this bill. Thank you.
Thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Janae Craddock with the Virginia Poverty Law Center. And not to restate everything but that has already been stated, but just wanted to say we do support this bill, and also to emphasize that this doesn't change what's in place. It strengthens the protections that's also in place. And this is an access to stable housing issue, and it helps to remove those barriers that people who have fulfilled their obligations under the lease term still suffer as a result of those visible evictions on their record.
Good afternoon, Chair and members of the committee. My name is Josue Castillo. I am a community organizer with New Virginia Majority, and the working class families that we serve, as well as organizations, support this bill.
Thank you.
Good afternoon. Sheila Hurley-Hennessy with the Virginia Interfaith Center for Public Policy. Associate my comments with those who came before and support the bill. Thank you.
Thank you. All right, anyone here wishing to speak in opposition to the bill, please come forward.
Thank you, Mr. Chair. Erin Corman with the Realtors. We do oppose this bill for several reasons. I think I heard a couple of the people testifying in support say that this doesn't change how things are done. It absolutely changes how things are done. I understand that a bill passed last year to allow for expungement, but our property managers do not have the ability to go through the reports and find out which unlawful detainers are eligible for expungement. There is a big difference here between denying housing because of a past unlawful detainer and taking an adverse action. And this bill prohibits all of those things. It says that we can't change the lease terms, we can't change the security deposit. and also doesn't say how a landlord is supposed to be able to prove that they did not take this into consideration. Even if they're not pulling the public court reports, this information shows up on credit reports, it shows up in landlord references, and this bill has $1,000 statutory damages if they are claiming that the landlord violated it. And we're going to have landlords in court trying to prove what they thought and what they considered. I don't see how it's logistically going to work, and because of that, the realtors do oppose the bill.
Thank you.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We really appreciate the intent of this bill, but it does hold housing providers liable for issues outside of their control. We rely on third-party screening services. A lot of these do not disclose the specific details of cases, and when rental applications are processed, decisions are made on a variety of factors like income, credit, outstanding debt, and not solely on one dismissed or non-suited case. And like what was mentioned last year, we worked on HB 73, which addressed this issue by requiring expungement of UD cases at the appropriate timeline. So thank you so much.
All right. Anyone on? So we have one person left online that I missed. Sheba Williams, you were here. You were online to speak in favor of the bill, I believe.
Yes, good afternoon. Sheba Williams, No Left Turn is also part of Allies for Housing Action. We support the bill. Thank you.
Okay. Any further questions from members of the subcommittee? All right, so we all understand what the bill does. We sort of see what the pros and cons of it are. Is there a motion? Move to report. There's no substitute, right?
No
substitute. Is there a second? All right. Are there any substitute motions? All right. Thank you, Dr. Hernandez. Why don't we move on to your next bill?
All right. So let's move on to flood disclosure. HB 2348. Oh, is it? Yes. Okay. Great. So I want to start by saying that we have worked on this issue for quite some time. I think that folks on this committee may know that I filed a very broad bill last year in the 2024 session. We have worked in good faith with everyone who will talk to us about this issue to try and find consensus, or at least close to it. The bill before you is really, honestly, quite very modest in what it does. All this bill does is say that when the seller, if the seller, and only if the seller has actual knowledge that the home that they are selling is in a flood zone, they have to disclose that to the buyer. That is literally it. This would not require disclosure in every instance, far from it. This, frankly, wouldn't even require disclosure in most cases. It's only where the seller actually knows. And, personally, I'm bringing this legislation because I live in Norfolk. We're ground zero for sea level rise, for land subsidence. It impacts quality of life all across Hampton Roads, which is why this bill is also a priority for the Hampton Roads Planning District Commission. But I would also say there's very similar legislation that sailed through the legislature in Texas that was signed into law by Governor Abbott in 2019 after Hurricane Harvey devastated much of the state. We had our own version of that just last year here in Virginia. We had Hurricane Helene, which talked to the members from Southwest, impacted them in terms of flooding. And that's why I'm actually quite proud. If you look at the co-patrons on this bill, chief co-patrons, Delegate Moorfield is a chief co-patron. Delegate Chad Green is a chief co-patron. Nadarius Clark is a co-patron. I will submit a little challenge. I'm not sure you'd find a bill this session where all of those folks are the co-patrons of legislation. I issue that challenge. But I'm just saying that to emphasize this is not regional. This is not partisan. For me, it's just about disclosing information that I think all of us, and certainly everyday working class people would want to know before they make the single biggest purchase of their life. I know we talk a lot about buyer beware, and I imagine that will come up today, and I'll send around copies of Upton Sinclair's The Jungle every time that is mentioned. This bill does not try to make us a seller-teller state. It's really, like I said, just a modest step that we're proposing for a region that's deeply impacted by flooding in Hampton Roads. So with that, that's the bill. Happy to answer any questions.
Any questions from members of the subcommittee? All right. Anybody here wishing to speak in favor of the bill in the room? Oh, here they come.
Mr. Chairman and members of the subcommittee, Mary Carson Stiff with Wetlands Watch. We, along with the Virginia Conservation Network, support this bill. We'd like to thank the delegate for his patronage of this legislation for the past 2 years. The work to pass smart flood risk disclosure laws actually started back in 2013. The legislature finally did speak in 2021, signaling that flood risk is important enough to not be considered strictly buyer beware. But our current disclosure law is simply not doing enough to protect potential buyers from making a purchase that they are not emotionally or financially prepared to sustain. The bill has been significantly modified in good faith at the request of the real estate community. It is the bare minimum disclosure of risk. The bill has significant bipartisan support with co-patrons from Southwest Virginia and Hampton Roads. This shows the deep consensus that disclosing whether a property is located in a FEMA flood zone is important to the southwestern and eastern parts of the state. As we all know, these areas experience increasing flood risk, and buyers must be given opportunity to have information about this reality. If a simplified, common sense bill like the one before you can't get passed in the Commonwealth, we are failing our residents and ignoring this dangerous and growing risk to our people. Thank you for your consideration.
Thank you.
Mr. Chairman, members of the subcommittee, Matt Mansell with Broad Street Group on behalf of the Environmental Defense Fund would like to thank the patron for his extensive and very hard work on this issue, and we support this legislation.
Thank you.
Mr. Chairman, members of the subcommittee, Trip Pollard with the Southern Environmental Law Center. We'd also like to express our support for this bill and thank the patron for all his work on it.
Thank you. All right. I think we've got a few people online wishing to speak on this bill.
There's just one out there.
Let's see. There's Morgan Butler. Mr. Butler.
Mr. Chair, members of the subcommittee. Can you hear me?
Yeah, go ahead. There's a little bit of a delay, but I'll stop talking so that you can start, and we'll wait until we hear your voice.
Great. I'm Morgan Butler with the Southern Environmental Law Center, and my colleague, Trip Pollard, just spoke in favor of the bill, so I don't need to repeat his comments. Thank you.
Thank you. There are some other people that were signed up, but I don't see that they've made it out of the way online.
Yeah, one additional supporter. I got a text from Sarah Taylor, City of Alexandria, also supports the bill.
Okay, Sarah Taylor with the City of Alexandria, and the city also supports this bill as written. All right, those in opposition to the bill that are in the room, please come forward.
Thank you, Mr. Chair. Erin Corman with the Realtors. We understand the intent behind this bill. We've seen it many times. We understand what we're trying to get to. The purpose of a mandatory seller disclosure is to let a buyer know about a specific known risk, okay? But in this case, the buyer is the only person who can determine what level of risk is acceptable to them. So mandatory flood insurance is only required in special flood hazard areas, and it's only required if they have a mortgage, and the mortgage, a federally backed mortgage, and the mortgage company lets the buyer know that they must have flood insurance to live at that property. There isn't a case where that buyer is going to be there and not know that. The buyer is only required to get coverage enough to cover the loan on the house. It's not even enough to cover the repair and the replacement of the property in most cases. These places in Southwest Virginia that flooded, I spent a very long time on the DCR website, which I'll give them a plug, is fantastic, looking up flood zones. They weren't in special flood hazard areas. Most of those areas wouldn't even have been covered under these disclosures. One of the primary reasons people do not get flood insurance is that they don't understand how their homeowner's insurance works. They think their homeowner's insurance covers flood. I don't know how many of you have done a rerun on your homeowner's insurance. I did one recently. Nobody told me that it didn't cover flood. They told me it didn't cover hail damage, but they never said it didn't cover flood. This is an education issue that I don't think the home sellers should have to bear. There's too much liability here, and it isn't giving the buyers the information they need. This is why we have extensive information in the buyer beware form. We passed the repetitive risk loss bill a few years ago that is a mandatory flood disclosure. We have a full flood risk information form available on DPOR that explains all of these things to the buyers. But again, the buyer is the only one that can determine what the risk is and what they are willing to take on when they purchase a property. So,
Ms. Corey, do you mind if I ask a quick question?
Maybe.
Go
ahead.
So you talked about the repetitive risk loss, and again, generally Virginia is a buyer beware state, but when it comes to flooding, I know that we've worked hard. I think 4 years ago when I chaired this subcommittee, we worked on a flood disclosure. So there actually is, I think if I understood you correctly, there is an affirmative disclosure, which is rare for our scheme, for somebody who's experienced actual claims. In other words, if their house is flooded, they've had to make claims more than once. That's a fact that they do have to disclose affirmatively. Is that right?
Right. If they've had damage and claims made to the National Flood Insurance Program, it's called a repetitive loss property, and it has to be 2 or more times within a rolling 10-year period.
All right.
And I think I saw a statistic the other day that 75% of those properties, 75% of our big flood issue properties are in the Delegates area. They're not in Southwest Virginia. Those properties are already, I want to say, they're in special flood hazard areas, but I think we also need to be aware those hazard areas are only updated every 5 years at minimum. I mean, we have some that are decades old and have not been updated. So.
Thank you.
You're welcome.
All right. Anyone else wishing to speak in opposition? Anybody else wishing to be heard on the bill? Delegate Hernandez, I think I got Delegate Thomas on the queue. So it sounds like the issue is where to sort of draw the line on this affirmative disclosure, right? The current law sort of draws it as a narrow category of repetitive risk loss zones. Your view is that that's too narrow a category, and that given the changes in the weather and environment, the big increase in flooding, we ought to expand it to all flood zones. Am I is that too simplistic, or is that about right?
I think that's basically right, Mr. Chair. I would just add that under paragraph A for the repetitive loss, it's the same touchstone standard of actual knowledge. So that actually only comes into play where the seller, again, has actual knowledge. So we tried to borrow that exact same phrase and just add the flood disclosure. So if the seller doesn't know or has no knowledge, they would be under no obligation, or they would have no duty to disclose. It's only in this narrow circumstance.
Gotcha. Okay. I just want to make sure I understood. Delegate Thomas, did you still want to be recognized?
Yes, Mr. Chair.
Delegate Thomas.
I don't know if this question is for you, Mr. Chair, for the patron, or for maybe the realtors, but I'm just trying to get educated on, because I do commercial, so I don't do residential law. For a buyer, what are they getting in the buyer beware document? It would be my question regarding this topic. Is that a document that they're getting as a buyer, and what's in it?
Do you want to talk to this too?
We can hear from either side. Why don't we let the patron, I'm sorry, Aaron, we can stand by, but if we can have you go ahead and pick your own expert, we'll let you do that.
Thanks.
Mr. Chairman, as Aaron stated, there is a flood form that is included on the DPOR website, and you have to go to the DPOR website to see the form. And so it's listed. It's not listed under, the actual disclosures. It's listed there. In the Code of Virginia, there is a list of things that the buyer should be aware of. I'm sure you all are familiar with that, and when you get your closing packet, you can see it. And so it's sort of like a waiver to disclose certain conditions. And so you have to disclose that the property, the buyer should be aware that the property could be located in the Chesapeake Bay Preservation Act area is one example, and a lot of other things. And so flood risk is also one of those enumerated lists in that provision online. And the buyer is notified when a mortgage is initiated by the mortgagee company that flood insurance would be required. And often this happens late in the process. And when a homeowner has seen the home is engaging in the contract process and then finding out that flood insurance would be required, may pull out of a deal. And in 2013, this was happening all the time because flood insurance was extremely expensive because of the Biggert Waters and Grim Waters Act. And that was a big complaint at the time. A lot of potential buyers were pulling out of real estate deals because they couldn't afford the cost. And so now you have an issue of the cost being high and a potential buyer saying, I think we could maybe stomach this. But now the way that flood insurance is rated, the National Flood Insurance Program is acting like a real insurance company, like a private company, and your premium, your rate, is a moving target, just like it is in regular insurance. And that is a huge concern, and the cost is increasing because of the reforms of the National Flood Insurance Program, and that's another big issue here. The affordability piece is really critical. Aaron, I hope I didn't mischaracterize.
Well, no, you didn't mischaracterize. That is the language on the form. I just want to make clear that the buyer is given that form at the very latest when they're making an offer. So before they're making an offer, the very latest when they're going over their offer to present it. It doesn't happen at the end. The agent is going over all of the things that the buyer should be aware of before they're putting their offer on paper. And that includes the flood risk. So.
All right. Any other questions from members of the subcommittee? All right. So I will say just my comment on the bill, and I certainly appreciate where you're coming from. I understand the policy difference. My concern, I'm often accused of being against disclosure, and I just want to be really clear that that's not the case. Here's my concern. My concern isn't about what happens when a seller tells someone that they know they're in a flood zone. My concern is for the buyer, the seller who doesn't know, and so doesn't disclose anything, and the buyer says, I'm not going to go look at the flood map. I don't need to go. That's a long, time-consuming, difficult process. I don't need to go through it because if there was anything wrong with the house as far as flooding was concerned, the seller would have had to tell me, right? And so since the seller didn't tell me, I'm going to forego the due diligence that I would have because if there was a real flood problem, they would have had to tell me they didn't tell me. And so that's why my strong preference, and I know I try and be consistent at least about this, right, is that don't expect to hear anything from me as the seller. You need to go figure out what you care about, what you're worried about. Don't accept my silence as an indication that everything's fine. And so I worry is when you start to put these affirmative disclosures in that you erode that sense and that the buyer gets this false sense of confidence having not heard that affirmative disclosure that they can disregard some of the other things we'd want them to do as far as floods are concerned. That's just sort of where I come from on that. It's not that I'm opposed to disclosure. I just, given how we sort of do things, if you start to mix and match, I think you start to chip away at that. So, Delegate Coiner.
Mr. Chair, similar thoughts on this is what I do for a living or settlements. I can't tell you how many folks buy a home, we give them their closing package with everything in it, and then years later they go to sell it and they call and they're asking me if I have da-da-da-da. I don't think I have it. And I'm like, no, it will be in your closing package from me, right? And then we go back and find it for them. And I don't think it's ever ill intent. It's just, again, the fact that sellers are not experts. And it's the reason why we encourage people when they're buying property to hire folks and experts to help them through the process, right? So that the biggest investment you're making, you've investigated and you looked at it. So again, I'm not opposed to disclosures either, but I think it's really important that buyers don't sit back idly and think this is being taken care of. And for that reason, I don't support the bill.
Any other comments or questions from members of the subcommittee? Any other comments or questions from members of the subcommittee? All right. Committee operates by motion.
Move to report.
It's moved to report. Is there a second?
Mr. Chairman, I have a substitute motion.
Substitute motion.
I move that we very gently and with the utmost respect lay the bill on the table.
It's been moved and seconded that we very gently and with the utmost respect lay the bill on the table.
It's a new one for me.
Clerk will open the roll. It doesn't say all that on the screen, but we all heard it. The clerk will close the roll. Thank you, Delegate Hernandez. Your bill is laid gently on the table. All right. Do we have any other bill patrons not on the subcommittee here? All right. Delegate Carr, you have another bill.
Yes. Thank you, Mr. Chairman. I have Bill 2149, the Zoning for Housing Production Act. Mr. Chairman, members of the subcommittee, I'd like to move the amendments which simply provide clarifying language on where some zoning practices can be deployed, as well as what grants can be spent on.
All right, so the motion is on the line amendments. This committee is in favor of the adoption of the line amendments. We'll say aye. Aye. Those opposed? All right, the line amendments are before us. Delegate Carr.
Thank you, Mr. Chairman. HB 2149 is just about identical to my legislation that passed this committee and this body unanimously. It would implement a recommendation from a 2021 JLARC study of the state's affordable housing needs. It creates a new program at DHCD to provide financial incentives for localities that modify their zoning ordinances to facilitate the development of more affordable housing. This bill acknowledges that statewide zoning mandates may not be effective for every locality and instead seeks to encourage localities to adopt currently available but underutilized zoning ordinances.
All right. Any questions for the patron from members of the subcommittee? All right, seeing no one in the queue, anyone here wishing to speak in favor of the bill in the room, please come forward. I see movement, but I don't think it's for this bill. All right, we have one person who's online. Oh, I'm sorry, coming to speak in favor of the bill.
Sorry, I was slow to hop up. Randy Grumbine, representing the Virginia Manufactured and Modular Housing Association. We are in support of the bill, and we thank the delegate for bringing it.
Thank you.
Erin Corman with the Realtors. We also support the bill.
The computer, too. Andrew Clark with the Home Builders. We also support the bill. Thank you.
You guys are doing a great job with the length of your testimony. Yeah. I appreciate it.
Isabel McLean, the Virginia Housing Alliance, and we also support the bill. Thank you.
Hi, Troy Garrett with the Virginia Association of Housing and Community Development Officials. We also support the bill.
Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management. We also support.
Trip Pollard with the Southern Environmental Law Center. We support as well. Thank you.
Thank you. All right. Is there anyone in the room, before we go to online, is there anyone in the room in opposition to the bill? All right. So having heard that there's no one in opposition, Dr. Giannakouros, did I get that close to right? Help me out with your last name. I want to make sure it's pronounced correctly for the record.
Thank you, Mr. Chair. Panagiotis Giannakouros, Harrisonburg with Virginia Progressives. We support this bill because it enables public planning processes rather than market forces to compete to drive where development should happen. The incentives it uses center people, encouraging localities to break down exclusion based on how they live rather than catering to developer incentives to economize on housing quality delivered. We prefer this bill to quantity bills we have opposed. Thank you, Mr. Chair.
Thank you. And thanks for that distinction. Right. It's been a motion to report as amended. It's been properly seconded. The motion, I think, is to report and refer to the Committee on Appropriations as amended. All right. Report and refer as amended. Properly seconded. The clerk will open the roll. The clerk will close the roll. Bill reports 8-0.
Thank you, Mr. Chairman.
All right, while we're waiting on patrons, we have some of our own bills, I know, but let's take care of a couple of administrative matters to clear the docket in case anybody is sitting around waiting for or online to talk about one of these bills. We probably should have done this at the beginning to help them not have to sit around for so long, but I forgot, sorry. House Bill 1943 from Delegate Cole. Delegate Cole has sent me a message indicating he'd like for this bill to go by for the week. Can I get a motion? Moved and seconded that House Bill 1943 go by for the week or by for the day, however you want to think of that. Those in favor of that motion will say aye. Aye. Those opposed? All right, 1943 is bye for the day. House Bill 2067 from Delegate Garrett having to do with consumer fireworks has been asked to go by for the day.
So moved.
It's been moved and seconded that House Bill 2067 go by for the day. As many in favor of that motion will say aye.
Aye.
Those opposed? That motion carries is by for the day. All right. We got Delegate Price. Do you want to go ahead and do your bill?
Sure. Thank you, Mr. Chairman.
House Bill 1719.
So you have seen this bill before, but just reminding you the intent behind it, that evictions harm communities, prevent folks from obtaining safe and secure housing in the future, harm the health and mental health of residents, exacerbate chronic absenteeism from unhoused students, have negative impacts on workforce development and business recruitment for regions, and more. So when you look at housing as like a critical need, we have been working especially hard since 2018 to prevent evictions. And again, this is what this bill intends to do. And so it would prevent a summons from unlawful detainers from being filed by increasing from 5 to 14 the days that renters have to pay their rent before the eviction process even gets started. So this change, we have heard, because this was in place during COVID, which was a crisis in and of itself, but we were already in a housing crisis prior to COVID. But it worked, and it allowed for people to get either their next check or to get to the point where they could go on and pay the rent, thus not even having to go into that eviction process. 21 states have pay or quit periods longer than 5 days, and all of them have lower rates of eviction than Virginia. And of those, the ones that have pay or quit periods of at least 14 days, meaning 14 days or longer, have an average of an eviction rate of 1.53%. Virginia has 5.12%. We have a problem, and so we are trying to get solutions in place that will continue to help, not on the back end, but specifically on the front end. So just reiterating that we are trying to prevent evictions. I hope everyone in this room continues to be embarrassed by the evictions lab data that Virginia had 5 of the top 10 highest eviction rates among large cities and 3 of the top 5 highest eviction rates amongst mid-sized cities in 2016. And so then when we had the pandemic, a lot of things got worse, but we put things into motion that helped people stay in their homes. For the COVID crisis, we are still in the housing crisis, and thus we are trying to, again, prevent evictions. So that is the bill, Mr. Chairman, and I can answer any questions.
Delegate Price, I just want to, is this bill substantially the same as the bill that passed off of the floor eventually with some Senate amendments last year?
Yeah, so this would be the version before, this would be the version after the Senate amendments. So it doesn't deal with the courts. It literally is just the 5 to 14 days.
Gotcha. Thank you, Delegate Price. All right. Any other questions from members of the subcommittee? All right. Anyone wishing to speak in favor of the bill, come forward.
Afternoon, Mr. Chairman. Jared Calfee with AARP Virginia. We support the bill. Many older Virginians are facing difficulties in paying for their housing. This bill would make it more likely that someone can get caught up on their rent, not face eviction, which is the outcome that everybody should want. We appreciate the delegate for bringing it forward again this year, and I hope you'll support the bill.
Thank you.
Hello, Mr. Chair, committee members. I'm Gustavo Espinosa with the Legal Aid Justice Center. We hear a lot about tenants needing to pay their rent on time. In my experience, tenants go weeks, months, years without their urgent needs being addressed, without the landlord fixing the fridge, stove, heat, leaks, rodents on time. When a landlord neglects their responsibility to maintain the property, their end of the bargain, most legal remedies available for tenants require they give their landlord at least 14 days. It's unfair and unreasonable that the landlord can take a tenant to court, disrupt their life, disrupt their children's lives after just 5 days. Please support this bill again. Thank you.
Thank you.
Mr. Chairman, members of the subcommittee, Christy Merrill with the Virginia Poverty Law Center, and I want to emphasize that this bill is about helping landlords get paid without going to court. This is about reducing our eviction filings, and giving somebody those extra 9 days at the front end of the process helps them get another paycheck, helps them get assistance from a local eviction prevention agency, and helps them make that payment before they are taken to court. I want to give you one statistic, and that is that we are still seeing an average of 11,500 cases filed, eviction cases filed every month statewide. And so while I think this committee and the General Assembly as a whole has done some really good work since 2019 to bring our eviction rates down, there is still a lot of work to do, and this bill, passing this bill, is an important part of that work. Thank you.
Thank you.
Good afternoon. My name is Jana Hobbs. I live in the city of Richmond, and I'm just asking that you support this bill because it almost triples the amount of time that a family with children could get to complete their rental payment, and keeps kids in bed at night instead of under a bridge. Thank you.
Thank you.
Chairman, members of the committee, Laura Dodds with Housing Opportunities Made Equal. I align my comments to the previous speaker. Support the bill. Thank you.
Good afternoon, Mr. Chair, members of the subcommittee. Isabel McLean with the Virginia Housing Alliance, and we also support the bill and associate ourselves with the previous comments.
Thank you.
Mr. Chairman, members of the committee, Jeff Caruso with the Virginia Catholic Conference. I just want to add that we heard from our Catholic charities agencies that this bill would be especially helpful for the clients that they serve. That's for two reasons. First of all, it would help them get a few more days to pull the funds together, try to help out. And secondly, as was noted earlier, a lot of folks are paid every 14 days, so this would align with that. Thank you.
Thank you.
Sheila Hurley Hennessy with the Virginia Interfaith Center for Public Policy. We also support the bill and align our comments. Thank you.
Thank you so much. And that is a fantastic way to do that. All right. And Ms. Williams.
Thank you, Chair Simon. Sheba Williams, No Left Turns. We support the bill. As a provider of eviction support since 2020, it is very difficult to process an intake application and connect with a landlord to get a payment paid in 5 days. I appreciate the bill. I know the honors. I know what the opposition is, but as a provider, it is easier to keep a person in place rather than try to place a family once they have been evicted from a property. So thank you.
Thank you. All right, those of you lined up to speak in opposition, come forward.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We have to strongly oppose this bill respectfully. We understand the intent and we sympathize with it, but frankly, extending the pay or quit timeline for 14 days is dragging out the eviction process to a max of 3.5 months. And what was mentioned, this is a COVID era bill where we had rental assistance. We had that extra, assistance for renters. That's expired. The state of emergency has now expired. And Virginia already provides numerous opportunities for renters to pay and stay, including the unlimited right of redemption, the right to pay in full up to 48 hours before an eviction is executed in a limited amount of time. So extending that timeline increases the debt residents also accrue, making it harder for them to recover financially. It also delays access to critical assistance from nonprofits and local programs that require action to intervene. We respectfully urge opposition to this bill, and it avoids creating deeper financial challenges for Virginia's most vulnerable renters. Thank you so much.
Thank you. Ms. Corbin.
Thank you, Mr. Chair. Erin Corman with the Realtors. We do oppose this bill. I just wanted to clarify because I heard several people get up and say that people were being evicted on day 5, and that's not how that's not how things work for our members. So the rent is late on day 5. I'm going to channel my inner Chip Dix here for you guys. The rent is late on day 5, and On day 6 is the day they file the 5-day notice. So they're not even going to the court now until day 11 to file the unlawful detainer, at which point we have to wait for a court date. And we all know that unfortunately that does not happen quickly. They're looking at another probably 30 days. So now we're into February before we can even get into a court. So it's not happening on day 5 that these people are being evicted. That doesn't take away the issue, and we do understand that, but we do have an unlimited right of redemption right now where tenants can pay all the way up to their court date, and this goes away, which is why we have the issue with unlawful detainers that came up in the earlier bill that are being dismissed and non-suited. And then they have, even if they do have to go to court, they still have a right of redemption all the way up to 48 hours before the eviction were to actually happen. And so for those reasons, we do oppose the bill.
Thank you.
Mr. Chairman, members of the subcommittee, Zach LeMaster here on behalf of the Northern Virginia Apartment Association, and we would so share our comments with the previous speakers.
Thank you. All right. Anyone else wishing to be heard on the bill? All right, seeing none, any questions from the subcommittee? Delegate Price, you want to get a last word in before we?
Yes, and I know we finding it. So this is something that was being passed around, and it shows the eviction process. What hasn't been said is all of this goes away if someone can pay their rent and not have to go through the eviction process. So I know a lot about the unlimited redemption because I carried the bill. But what I also know is that if someone has to get all the way to the end and do a right of redemption, credit has already been hit. They have to pay the court fees, fines, and whatever else, the sheriff's stuff, all of that. The amount of money has gone back up. And so what we are trying to do is prevent that. And so I'm very aware of all of the things that we've been trying to do because I promise you, I've been trying to patron, co-patron, and get as much as we can because a name was invoked, and that was the name that was killing all the bills when I first got here. So we have a lot of catching up to do in order to get a place where we are more equitable in the relationship between the landlord and tenant. I am not trying to hurt any landlord. I'm not, but I am trying to think of all of the kids that are in Newport News Public Schools who are unhoused because their parent didn't have another chance to get to that next check. And so I get it. It's not going to be perfect. It's not going to be all of that. But to say an unlimited right of redemption or the back end stuff is available, that's great because I helped do it. This is for that front end to prevent it from even getting there so that it's not as costly for the renter or the landlord. And I thank you for your time, Mr. Chair, and for hearing this because I think it is that important.
Delegate Delaney.
Wrong
Delegate Delaney, sorry.
Wrong Carrie.
Delegate Coiner. Wrong Carrie.
Wrong corner.
Thank you, Mr.
Delegate
Chairman.
Coiner. What did I say? I finally got it right. Delegate Coiner. Did I say Delegate Carey? I'm
Yeah,
sorry.
you said Karen.
Delegate Coiner.
That's okay.
It's been a long afternoon.
It has been. I no longer do landlord-tenant as part of my real estate practice. I only help buy and sell homes. But what I will tell you for those attorneys who do with me, we wish that when you got that first notice that you did pay up front. But the reality is the vast majority of people don't make payment until you show up to court. It's just reality. They wait as long as possible. And my fear continues to be the longer we postpone and drag out that sequence, the more debt people are racking up and attorneys' fees and fines. And it's the reality of how people wait to make payments in practice. So for that, I am not supporting the bill.
All right. Committee operates by motion. Delegate Carr.
Move to report.
Second. All right, it's been moved and seconded that the bill report. The clerk will open the roll.
I was going to do it. He saw me moving forward, too.
The clerk will close the roll. The bill reports 5-3. All right, thank you, Delegate Price. Delegate Maldonado, followed by Delegate Sewell, unless she leaves again.
Thank you. Good afternoon, Mr. Chair, members of the committee.
I am here to talk about HB 2122. There are two components to this bill. The first is very simple.
Hold on, I'm sorry. Very quickly, I apologize. We go out of order because, again, if anybody is here for House Bill 2229, if that's the only reason you're here, Delegate Cousins has indicated she's not going to be able to do her bill, so we're going to take that one by for the day. So can I get a motion to take House Bill 2229 by for the day? It's been moved and properly seconded. Somebody's fair that motion will say aye. Those opposed, no. All right, 2229, Delegate Cousins is by for the day. All right, Delegate Maldonado, I'm sorry. We're now back to 2122.
Thank you. Well, that gave me an opportunity to remember that there's an amendment with the nature of a substitute.
That's what I was trying to do for you.
Thank you, Mr. Chair.
Go ahead. No.
I move to substitute. Second.
All right, it's been moved and seconded. We adopt the subcommittee substitute. As many as favor that motion will say aye. Those opposed, no. The motion carries. The substitute is before us. Delegate Maldonado.
Thank you, Mr. Chair. Members of the committee, thank you. Good afternoon. This bill, amendment in the nature of substitute, addresses two critical issues. The first, you may recall that last year we passed a bill that made the fees in rental agreements be moved up front and placed very prominently in our lease agreements, which was a wonderful bill, piece of legislation. The challenge was that it was not also included in rental agreements for folks living in mobile home communities. So the first part of this bill just makes sure, or the second part of this bill, just make sure that that fee disclosure requirement also applies to folks who are renting mobile homes. The second part is around what is happening around flood zones. Our mobile home communities are very vulnerable in flood conditions and changing climate conditions. Tenants may be unaware that their manufactured home is located in a special flood hazard area. As the owner of the community and as the holder of the deed is the only person who is required to be provided the notice that the community or part of the community is in a special flood hazard area by FEMA. So Hurricane Helene's destruction of Southwest Virginia highlights the potential devastating impact of flooding that can have on communities that are made up of mobile homes in the Commonwealth, and tenants face a greater risk of insurance claims denials for flooding if the home is in a special flood hazard area that was not disclosed to the insurer at the effective date of the insurance policy. So we have worked really hard across stakeholders to provide this disclosure inside the lease of these tenants for mobile home communities that would make it clear that the homeowner's insurance does not include flood insurance and that they may need flood insurance, and to provide information on where to obtain it. Thank you, Mr. Chair. Members of the committee, I will be here for questions.
All right, Delegate, I have a question for you.
Yes, Mr. Chair.
I think I know the answers. It's probably going to be yes, so stay with me. So this is going to go into every lease for mobile homes. So whether or not it's in a flood zone, so it's not if you have knowledge that you're in a flood zone or anything like that. This is going to every lease that says you may be in a flood zone. We don't know, but you need to check, because if you are, you're going to need insurance. Is that essentially how the bill works?
Mr. Chair, yes, the language, there is some flood information that's available, but it's not as prominent. And because of the climate changes, we're seeing more and more flooding, and mobile homes are particularly susceptible. And so we're allowing for inside the lease itself for people to be better informed.
You weren't here for an earlier bill. I just wanted to distinguish the nature of this disclosure from one that we talked about in an earlier bill.
Thank you, Mr. Chair.
Thank you. All right, any other questions from members of the subcommittee? All right, anyone in the room wishing to speak in favor of the bill?
Yes, we did.
Okay. Randy Brownbine, representing the Virginia Manufactured Modular Housing Association. We appreciate the delegates' work on the bill, and also Daniel with the Virginia Poverty Law Center. We got to a comfortable place on this, and we're happy to put that disclosure in the lease.
All right, very good. Before you keep going, is there anybody here in opposition to the bill? All right, seeing none, with that in mind.
Yes, Mr. Chair. Daniel Rezai, Virginia Poverty Law Center. We happily support this bill. Thank you.
Thank you.
And I won't flood you with too much.
Oh.
No, Tyler.
It's just a steady stream, though, a steady stream of positive.
Tyler Craddock, Manufactured Housing Communities of Virginia. We do appreciate Delegate Maldonado's leadership in working with us on it, and folks from Poverty Law as well, and we support the bill.
Thank you.
Hello again, Mr. Chair, Committee. Thank you, patron, for the bill. And I mostly want to use this as a helpful reminder that when we amend things for those who live in apartments and stick-built homes, we should be trying to get those same protections for mobile home residents as a matter of practice. So thank you very much for doing that.
Thank you for that reminder.
Mr. Chair, members of the committee, Sheila Hurley Hennessy with the Virginia Interfaith Center for Public Policy. We also support the bill. Thank you.
Chairman and members of the committee, Kashish Pillay with New Virginia Majority, and on behalf of Tenants Workers United, we support this bill. Thank you.
Thank you. Sounds like a broad spectrum of folks. And again, I asked for anybody in opposition, didn't see anybody. Committee operates by motion.
Second.
It's been moved and seconded that the bill report with substitute. The clerk will open the roll. The clerk will close the roll. The bill reports 8-0. Thank you, Delegate Maldonado.
Thank you, Mr. Chair.
Delegate Sewell. She's not, but Josh is going to do hers.
Thank you,
House
Mr.
Bill
Chair.
1879.
Yes, thank you, Mr. Chair and members of the subcommittee. I bring forward House Bill 1879. And we have a substitute with a few line amendments.
So is it a substitute that makes line amendments, or is there going to be some more line amendments after we do the substitute?
It's just 4 line amendments.
Right. Okay, so it's line amendments. All right, so we have a motion to adopt the line amendments, properly seconded. As many as favor that motion will say aye. Aye. Those opposed? All right, the bill with line amendments is now before us. Delegate Sewell.
Thank you, Mr. Chair. House Bill 1879, co-patroned by Delegate Coiner, is an opportunity for the Commonwealth of Virginia to establish a pilot program for rental assistance for qualifying households. This will be applied to 5,000 families who qualify, and I will walk through those parameters here very shortly. But most notably, this is an effort to address our ongoing housing crisis. Over half of Virginia renters' households are currently burdened, meaning that they pay more than 30% of their income on housing costs, and approximately 347,000 Virginians who qualify for federal rental assistance, the Housing Choice Voucher Program, are unable to access it due to a lack of funding from Congress. So this is our way of taking an opportunity to establish a 3-year pilot program at the cost of $80 million over the 3-year period of time. That made you perk up. You're excited. I appreciate you. To ensure that 5,000 low-income families with school-age children are able to remain in their housing. We know that housing instability has been an issue of concern for years, but has never been more critical than now to be addressed. And the lack of housing stability is a precursor to many challenges, to include the impacts on childhood development, which is among many of the issues that we're trying to face and address in this issue. So that being said, over that 3-year pilot program, the $80 million will be allocated accordingly. And the requirements which allow for an individual to qualify for this program is that they have to have at least one child within the home who is 16 years or younger, in addition to qualifying based upon the parameters which are designed for this program.
All right, thank you. No, I perked up because now I understand why I have a note that this bill needs to go to appropriations. It makes perfect sense to me now.
That too.
All right. Is there any questions from members of the subcommittee about this bill? Anybody in the audience wishing to speak in opposition to the bill? All right. Seeing none, is there anybody who wishes to speak in favor of the bill or indicate their support for the bill? Come on forward real quick.
Hello again, Mr. Chair, members of the subcommittee. Isabel McLean with the Virginia Housing Alliance, and we strongly support this bill and thank the patron and our other patron for working on this issue. In particular, we support this program because it will empower Virginia families and our children by ensuring that they have stable housing and thus a strong foundation for success at school and beyond in the short term and long term. So we ask that you support the bill. Thank you.
Hello, good afternoon, Chair, Committee. I'd like to thank both patrons for the bill as well as their powerful words yesterday at the press conference, focusing on stability and the importance for health and education outcomes. So thank you very much. We support this bill, the Allies for Housing Action.
Great, thank you.
Associate my comments with those who came before. Virginia Interfaith also supports this bill.
Thank you, Virginia Interfaith, for that.
Christy Mayer of Virginia Poverty Law Center, and we also support the bill and associate ourselves with the previous comments.
Thank you so much.
Come on over.
Good afternoon. I'm Jana Hobbs, member of New Virginia Majority and a resident of the city of Richmond. And I'm asking you for all of these reasons and for you to care about the children of the Commonwealth as much as we all do. Keep them in their homes and their beds at night so they can learn.
Thank you.
Chairman Laura Dawes with Home of Virginia, and we support the bill.
Thank you.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and Virginia Apartment Management, and we strongly support. Thank you.
Thank you. All right. All right. Committee operates by motion.
Move to report.
It's been moved and seconded that the bill report with amendments and report to the Committee on Appropriations. So the move is to report and refer with amendments. That's what I heard, right? Yep. All right. It's properly seconded. The clerk will open the roll. I wish I could spend $80 million without Luke's permission, but the clerk will close the roll. What's my microphone on? The clerk will close the roll of bill report 6-2.
Thank you,
All
Mr.
right.
Chair.
Delegate Thomas, you have graciously agreed to present Delegate LaVere Bowling's bill for her. She's tied up in the somewhat less powerful Labor and Commerce Committee. But nevertheless, we'll excuse her and we'll let you go ahead and present her bill. So go ahead.
Thank you, Mr. Chairman. This is HB 1932. First, I'd like to move the amendments. I think there's, 5 line amendments here.
Second.
It's been moved and seconded that we adopt the line amendments. As many as favor that motion will say aye.
Aye.
Those opposed, that motion carries. HB 1932 is amended is now before us. Delegate Thomas.
And if council could just, does everyone have access to the line amendments? I guess that'd be my question. Okay, great.
They're online.
All right.
And it looks like we just add a couple of representatives to a work group, but go ahead.
Correct. Mr. Chairman, members of the committee, before you is HB 1932, which addresses racial bias in home appraisals, a persistent issue contributing to the racial wealth gap. Homes in minority neighborhoods are frequently undervalued compared to comparable homes in white neighborhoods, resulting in significant financial disadvantages for homeowners of color. A Brookings Institution study revealed that homes in majority black neighborhoods are undervalued twice as often as those in majority white areas, with disparities in appraised values costing black communities an estimated $162 billion in lost equity. Additionally, these biases extend to other minority communities such as Indigenous, Southeast Asian, and Pacific Islander populations, exacerbating economic inequalities. The bill establishes a task force on property appraisal and valuation equity to combat appraisal bias and promote fair housing valuation practices. Comprising representatives from government, real estate, banking, and consumer advocacy sectors, the task force will develop strategies to reduce bias, increase diversity in the appraisal profession, and improve oversight of valuation standards. It will also explore tools for reconsidering disputed valuations and addressing biases in automated valuation models. Through its annual reports to the Governor and General Assembly, the task force will recommend legislative and policy changes aimed at achieving equitable property valuation across Virginia. By tackling appraisal bias, HB 1932 seeks to advance economic justice, close the racial wealth gap, and ensure that all communities benefit fairly from home ownership. And I know it is the delegates' hope that the committee will report the bill.
All right, and refer it to appropriations.
Refer to appropriations.
Just because we do have a letter on this one they want to have a look at as well. All right, anyone in the audience wishing to any questions for Delegate Thomas on Delegate LaVere Bowling's bill? All right, we'll spare you that. Anyone in the audience wishing to speak in favor of the bill? And if you could, in your testimony, to the extent you need to, explain why we should use this specialized task force and not rely on another existing group to do this work, would be useful to hear.
Sure. Thank you, Chairman. Members of the committee, Laura Dodds with Housing Opportunities Made Equal. This is a really large, complex issue involving not just the need to get more appraisers and make it easier for people into the profession, but also taking a look at how we do reconsiderations of value when someone has an appraisal that comes on that seems suspiciously low. Right now, those are very costly and to do and difficult. We want to ease that process and make sure people get their fair value. We want leading experts in this work group at all levels to ensure that not only are we looking at the regulations for appraisers, for qualifications, how reconsiderations are done, how people get into the profession, and how we're enforcing whenever there are instances of appraisal bias that I think this other work group would be more equipped to handle. Thank you.
Thank you.
As Chairman, members of the subcommittee, Christy Mara with the Virginia Poverty Law Center, and I associate myself with Ms. Dobbs' comments and just emphasize that because of the highly technical and highly specialized nature of some of the issues that this task group will have to deal with, it really is important to have a separate group with people with expertise in those areas that can actually dedicate sufficient time and knowledge to coming up with recommendations in this area. We strongly support the bill.
Thank you.
Virginia Interfaith Center for Public Policy also supports the bill and associates our comments. Thank you.
Thank you.
Hello once again, Isabel McLean, Virginia Housing Alliance, and we also support the bill and associate ourselves with the comments.
All right, thank you. All right, we got one person online, Sheila Williams. Sheba, excuse me.
Yes, good afternoon, Chair, again. This one is personal, and it is not about my criminal justice advocacy. I am born and raised in Churchill in Richmond, Virginia, and when I wanted to move back and buy my home, we were discriminated against by Monarch Mortgage, clearly. I have income, assets, and credit. My credit score has been 830 consistently for the past 6 years since we purchased our home. Our first appraisal was for $237,000. Our next appraisal was for $205,000, which is only $5,000 above the value of our home, contrary to any improvements we made. In this area where I am from, because I wanted to stay close to where I was born and raised, there is a consistent undervaluing of the homes in our area. The builders do not invest properly in this area, and it is a problem. It is a problem that appraisers are able to be biased against a homeowner because of their skin color, because they assume their income levels are lower. This is something that I support. And aside from anything that I do in the work group, this is something that has personally impacted me, and I would love to see more training and accountability for appraisers who throw a number on something and give the lowest appraised value simply because of the area that they are in or the face of the homeowner. So thank you.
Thank you. All right. Anyone wishing to speak in opposition to the bill? All right. Any questions for Delegate Thomas on behalf of Delegate Libby Bowling? Well, we'll see how it goes. We'll see if we get a motion.
Move to report as amended and refer to appropriations.
Is there a second? Delegate Thomas? Second. You can second it? You just presented it. All right, it's been moved and seconded that report we refer to appropriations as amended. All right, the clerk will open the roll. The clerk will close the roll. Bill reports by a vote of 6 to 2 and is referred. Report with recommended referred. All that what it says there. To appropriations by a vote of 6 to 2. All right. I think we're down to my bills, right?
Thomas has a bill.
Thomas has a bill? All right, Delegate Thomas, your own bill.
Thank you, Mr. Chairman. I can pivot if that's what you want. This is fine. So before you is HB 2065, which has no amendments or substitutes. So the federal government is transitioning from the National Fire Incident Reporting System to the National Emergency Response Information System. In Virginia, only about 2/3 of the localities report to, I'm probably not going to pronounce it the way that it's pronounced, but INFERS, leading to the inability of the state to make data-driven decisions about the fire service. Localities receive aid to localities funds annually based on population. What this bill would do is require localities to report to NRS to receive those aid to localities funds, and the bill would improve data-driven decisions on the local, state, and federal levels in regards to fire reporting.
All right, thank you. I'm not seeing anybody in the queue from the subcommittee to ask questions. Is there anybody here speaking in favor of the bill? Come forward. I know you've been here I was going to skip you, but I think it's an easy bill, but you've been here all day, so I'll let you testify.
Thank you, Mr. Chair, members of the committee. William Dantini speaking on behalf of the Department of Fire Programs. We support this bill because it'll bring better decision-making for our agency in the Commonwealth. It'll help provide better eligibility for the 46% of localities that do not report for federal grants. Lastly, it has a delayed enactment, and the bill will have a compliance policy set by our Virginia Fire Services Board, which has stakeholders with our fire service stakeholders, as well as the Association of Counties and the Virginia Municipal League. And lastly, this bill has passed through the Senate.
All right. Oh, that's a bad news. But anyway, despite that last bit of information, is there a motion to report?
Second.
It's been moved and seconded.
Mr. Chairman.
Mr. Big Chair.
All right, just a quick question. I noticed there was some interesting language in here that says, in accordance with the requirements set by the governor's appointed fire services board. Is there another fire services board that would compete with the governor's fire services board?
That is the one and only fire services board.
Okay, Mr. Chairman.
Mr. Big Chairman.
I would be interested. I don't know that we have ever specified who appointed anything, and I would make a motion that we strike the language in there about the governor's appointed and just refer to the fire services board.
So strike after the word set, strike by the governor's appointed, or no, I'm sorry, after the word strike governor's
set
appointed.
by the fire services board.
Set by the fire services board. Is there a second?
Second.
It's been moved and seconded that we strike governor's appointed on line 69 and 70. Somebody for that motion will say aye. Aye. Those opposed? Motion carries. Bill is amended. Is there a motion to report with amendments?
Second.
It's been moved and seconded the bill report as amended. As many as favor that motion will say, oh no, we'll open the roll for that one. Wish it were that easy. The clerk will close the roll. Bill reports as amended, 8-0. All right. Douglas, do you have a bill?
Next committee, maybe.
Next committee.
Next committee. You're
All right.
early.
You're early.
That's all right. You can hang out. I'm going to try and go quick. All right. Chair Carr, if you could take over for me.
Yes, indeed.
All right, my first bill is House Bill 2110. What this bill does is add language that says that no association shall require the seller or seller's agent to provide the purchaser's name prior to preparing a resale certificate. So when you buy a house that's in a condo or homeowners association, you're entitled to receive a resale certificate. The statute provides that two different lengths of time to cancel the contract. It anticipates that in some instances, the seller will want to go ahead and get that resale certificate in advance so they can give it to the buyer immediately upon ratification of the contract. In practice, many associations have started saying, we're not going to prepare the certificate or give it to you until you tell us who's buying the property. Well, I don't know who's buying the property until I have a contract. This bill says you can't do that anymore. You got to give them the certificate when they need it. And what happens is realtors are very creative, and they often will list their brother-in-law, their cousin, their nephew, just to get a resale certificate. It seems silly to have to do that, and so this bill just sort of conforms to law to what the actual practice is in the original intent of the bill.
Any questions from members of the committee? Any comments from the audience in favor? Anybody opposed? All right, committee moves by motion.
Second.
Let's take it to the board. All in favor?
All right.
Chair Simon, your Bill 2110 passes 8-0.
All right, thank you. And let me next do 2430. And there is a substitute.
All in favor?
Aye. All right, and Madam Chair, with the substitute, I think we have a consensus bill that's been agreed to by all of the stakeholders. So you'll recall that a year ago, we passed a bill that required a statement be added at the beginning of rental agreements that included a quote-unquote a description of any fees, rents and fees to be charged to the tenant in addition to the periodic rent. And that language was so broad that the resulting form, which was designed to provide some simplicity for tenants and buyers to know up front, just a quick list of what you're going to have to pay every month. Because it's sort of a description of all the fees that may or may not be charged, the form itself that was supposed to be easier was like 2 or 3 or 4 pages long with like tables and charts, and it turned out not to be a really useful disclosure, and it wasn't helpful in simplifying the process. So the apartment office builder folks in VAMA came to me and said, here's what we've produced based on the legislation you passed last year. Is there any way we can sort of pare this down so that it's actually more useful for consumers? I said, if, this is why it says by request on it, if you can get buy-in from everybody, and they all agree that this doesn't undo what we did, but is actually an improvement to what we did last year, or at least doesn't do any harm to what we did last year, then I would support such a bill. The substitute, I understand, is such a compromise, and this language does reflect a consensus among all those stakeholders that what's left in this bill is going to make for a more useful and meaningful disclosure for everybody, but doesn't leave anything important out that a tenant would need to know.
Questions from members of the committee? Anyone in the audience have questions? Anyone to speak in opposition to HB 2430? Committee moves by motion. Second?
Yes.
All in favor? Let's all go to the board. That's a twofer, Mr. Chairman.
Thank you. All right, last one of this very lengthy meeting is deed fraud, which is House Bill 2396. I have a substitute for this bill.
All in favor?
Aye. All right, so what the substitute does is create a work group. All right, so this goes to a Section 1 bill. And again, just very briefly to identify the problem that we're trying to solve here, it is a problem that is growing that because of the openness and access to land records and listings and things like that on the internet, that there's a problem with folks searching land records and searching public information to find vacant properties and listing that, and then imitating the seller, holding themselves out as the owner of those properties and listing and selling those properties without actually being the actual owner of the property, and then forging a deed and getting it recorded in the land records, and then attempting to collect the buyer's funds by selling vacant parcels that they don't actually own, and sometimes abandoned parcels and things like that. We had a couple of different ideas about how we could go about fixing that and who we should put in charge of actually making sure you're dealing with a real person, whether it's the responsibility of the real estate agent, the clerk of the court, the notary, the settlement company. Nobody really wanted to take on 100% ownership of being fully responsible for verifying that. So what we result is we're going to have a work group under the Virginia Housing Development Authority, a technical advisory group. One to figure out how big a problem this is, what some of the causes are, including notary fraud, seller impersonation, owner impersonation, fraudulent lien filing, and develop recommendations to prevent it and develop measures to enhance protections for property owners. And then we'll have the relevant stakeholders get together there and hash out the details, including the clerks of the court, the Community Associations Institute, the Association for Commercial Real Estate, the home builders, the Virginia Municipal League, the notaries, the Land Title Association, the Mortgage Bankers Association, the Realtors, the Bar Association, and the Real Estate Council. So all those folks would be at the table, and we would figure out the best way to, what if anything we can do to prevent this growing and more prevalent form of fraud.
Questions from members of the committee? I have one. So the group will decide how big a problem this is or where it's coming from?
Yes. So one of the functions of the work group would be to say, hey, is this a problem? We won't decide it's a problem. It's clear it's a problem. I guess they'll decide the scope of the solution, right? In other words, depending on how prevalent this is, will depend on sort of how extreme of sort of steps we need to take to change what happens in Virginia law, and whether the things that we need to do are appropriate to the scope of the problem. I think that's what that language is meant to convey.
All right. Any comments from the audience? Those in favor of this bill? Anyone opposed?
Oh, you got somebody.
Oh.
She worked very hard.
Definitely not opposed. Erin Corman with the Realtors. Just want to thank the delegate for really working with us and helping us with this bill. Deed fraud is a huge issue in the Commonwealth, but it covers so many different things. It covers whether the seller is actually the legal owner. It covers fraudulent liens being filed on properties. And we really wanted to try and come at it in a lot of different directions, from notaries to attorneys to the land records office, the clerks. And this study is going to allow us to bring everybody together and really try and attack it on a lot of different fronts. So thank you very much. We appreciate it, and ask that you pass the bill.
Thanks. Anyone else to speak in favor? Did someone come up? Anyone to speak in opposition to the bill? All right.
Vote to report.
All right, let's go to the board.
Thank you.
It's a 3-4. 8-0.
Thank you, Delegate Carr. Helps to be the chairman of your own subcommittee. And then it looks like Delegate Bennett Parker did not make it back, so we're going to go ahead and take, we have Delegate Bulova, Mr. Chairman.
Mr. Chairman, so just wanted to make a statement, and then I've got a motion. Our very eagle-eyed and intrepid senior attorney caught something within Delegate Thomas's 2065. And so.
So entertain a motion to reconsider the bill by which we reported.
On the prevailing side by which we reported that bill, I move that we reconsider.
And I will second that.
As many as favor the motion to reconsider will say aye. Aye. Those opposed, all right, the bill is back before us.
All right, so Mr. Chairman, apparently the formal name of that board is the Virginia Fire Services Board. So you have to add the term Virginia to make it consistent. So we could get rid of the governor's appointed stuff, but we need to call it the Virginia Fire Services Board. Ashley also noticed that on line 81, there is another place where we leave out the formal name with, it just says Fire Services Board, not Virginia Fire Services Board. And so she says this has been keeping her up at night for years. Okay. And this is her opportunity to make sure we clean up the code and it all works well together. But Mr. Chairman, my motion would be to add Virginia before Fire Services Board on line 70 and Virginia before Fire Services Board on line 81.
So moved.
It's been moved and properly seconded. As many as favor that motion will say aye.
Aye.
Those opposed? All right, the motion carries.
All right, Mr. Chairman.
Do you have another motion?
I would move that we, I would move the bill as amended.
Report the bill as amended. Is there a second? Second. All right, moved and seconded that we report House Bill 2065 with amendments.
And refer.
Does this have a referral?
No.
No.
Doesn't it put it appropriate now?
Don't try to go.
No letter.
No
Report and
letter.
refer. That may change before full, but right now, there's no letter. Clerk will open the roll. The clerk will close the roll. That bill reports again 8-0. Thank you, Ms. Benz, again. And before we adjourn, you guys all heard and you all watched. We had a number, I think about, 4/5 of the bills that we saw had line amendments or substitutes. Those things don't write themselves. They don't get to us in a timely fashion without a great deal of work from council. So I know this was a killer docket and it's been a super short session. So Ashley, Ms. Gropper, Ms. Benz, can we give a round of applause to our attorneys? And even with all that, they catch our mistakes that we try and make on the fly when we do things back here without talking to them first. So with that, the committee shall rise.